All right, welcome gentlemen to our very first walkthrough of Bingo on the Bench. We are trying to implement a more fun and inclusive way to get through some of the dry cases that we read through in constitutional law here at St. Thomas. It will work as follows. I will read through the case at hand, and as I go through the case, you will look down to your bingo cards and you will try to match any of the topics or considerations as I go through. As I go through it and you see something that does match, raise your hand, but do not interrupt me. We will get through the entirety of the case and we will try to see if anybody has reached bingo by the end here. And then we will walk through each of your spaces and I will either sustain or overrule your judgments. Does that make sense to both of you? Once we get through the end of this, whoever has reached their bingo will have a nice reward for them at the end. I'm excited. I hope you are all excited as well. All right, to begin, Chief Justice Taft delivered this opinion to the court. The child labor tax law is attacked on the ground that it is a regulation of the employment of child labor in the states, an exclusively state function under the federal Constitution and within the reservations of the 10th Amendment. It is defended on the ground that it is a mere excise tax levied by the Congress of the United States under its broad power of taxation. We must construe the law and interpret the intent and meaning of Congress from the language of the act. Does this law impose a tax with only that incidental restraint and regulation which a tax must inevitably involve? Or does it regulate by the use of the so-called tax as a penalty? If a tax, it is clearly an excise. But this act is more. It provides a heavy exaction for a departure from a detailed and specified course of conduct in business. That employers shall employ in mines and quarries children of an age greater than 16 years, in mills and factories children of an age greater than 14 years, and shall prevent children of less than 16 years in mills and factories from working more than 8 hours a day or 6 days in a week. If an employer departs from its prescribed course of business, he is to pay the government 1/10 of his entire net income in the business for a full year. A court must be blind not to see that the so-called tax is imposed to stop the employment of children within the age limits prescribed. It is prohibitory and regulatory effect, and its purpose are palpable. All others can see and understand this. How can we properly shut our minds to it? Out of a proper respect for the acts of a coordinate branch of the government, this court has gone far to sustain taxing acts as such, even though there has been ground for suspecting from the weight of the tax it was intended to destroy its subject. But here, the presumption of validity cannot prevail, because the proof of the contrary is found on the very face of the provisions. Grant the validity of this law, and all that Congress would need to do hereafter in seeking to take over to its control any one of the great number of subjects of public interest reserved to the states would be to enact a detailed measure of complete regulation of the subject and enforce it by so-called tax upon departure from it. To give such magic to the word tax would be to break down all constitutional limitation of the powers of Congress and completely wipe out the sovereignty of the states. The difference between a tax and a penalty is sometimes difficult to define, and yet the consequences of the distinction is the required method of their collection often are important. Where the sovereign enacting the law has the power to impose both tax and penalty, the difference between revenue production and a mere regulation may be immaterial, but not so when one sovereign can impose a tax only and the power of regulation rests in another. Taxes are occasionally imposed in the discretion of the legislature on proper subjects within the primary motive of obtaining revenue from them and with the incidental motive of discouraging them by making their continuous onerous. They do not lose their character as taxes because of their incidental motive. But there comes a time in the extension of the penalizing features of the so-called tax when it loses its character as such and becomes a mere penalty with the characteristics of regulation and punishment. Such is the case here. The case before us cannot be distinguished from that of Hammer v. Dagenhart. This case requires the application of the principle announced by Chief Justice Marshall and McCulloch in a much-quoted passage, the pretext passage. But it is pressed upon us that this court has gone so far in sustaining taxing measures, the effect or tendency of which was to accomplish purposes not directly within congressional power, that we are bound by authority to maintain this law. The first of these is VZ Bank v. Venno. In that case, a law which increased the tax on the circulating notes of persons and the state banks from 1% to 10% was upheld. It will be observed that the sole objection to the tax it was excessive character. There were no elaborate specifications on the face of the act, as here, indicating a purpose to regulate matters of state concern and jurisdiction through an exaction so applied as to give it the qualities of a penalty for violation of the law rather than a tax. But more than this, what was charged to be the object of the excessive tax was within the congressional authority. After having pointed out the legitimate means taken by Congress to secure a national medium or currency, the court said, having thus, in the exercise of undisputed constitutional powers, undertaken to provide a currency for the whole country, it cannot be questioned that Congress may, constitutionally, secure the benefit of it to the people by appropriate legislation. To this end, Congress may restrain, by suitable enactments, the circulation as money of any notes not issued under its own authority. The next case is that of McRae v. United States. That, like Vesey, was the increase of an excise tax upon a subject properly taxable in which the taxpayers claimed that the tax had become invalid because the increases were excessive. It was a tax on oleomargarine, cent a pound, and it was a substitute of butter. And then the white oleomargarine was 1/4 of a cent a pound, and then the yellow oleomargarine was 10 cents per pound. This court upheld the tax, applying the same principle as that applied in Vesey. It was that Congress, in selecting its subjects for taxation, might impose the burden where and as it would, and that its motive disclosed in its selection to discourage sale or manufacture of an article by a higher tax than on some other did not invalidate the tax. Finally, in United States v. Dormus, which involved the validity of the Narcotic Drug Act, imposed a special tax on the manufacture, importation, and sale or gift of opium or cocoa leaves or their compounds or derivatives. It required every person subject to the special tax to register with the collector of internal revenue, his name and place of business, and forbade him to sell except upon the written order of the person to whom the sale was made on a form prescribed by the Commissioner of the Internal Revenue. The validity of the special tax and nature of an excise tax on the manufacturer, importation, and sale of such drugs was, of course, unquestioned. The provisions for subjecting the sale and distribution of the drugs to official supervision and inspection were held to have a reasonable relation to the enforcement of the tax and were therefore held as valid. The court said that the act could not be declared invalid because another motive than taxation, not shown on the face of the act, might have contributed to its passage. Affirmed. Justice Clark filed a lone dissent.
Judge, I said it was me.
Order. Michael, you first.
All right, here's the one that I have in a row. First one, impassioned dismissal of the party's argument, you must be blind. Congress disguises the penalty as a tax. Congress attempts to preempt exclusively state functions under the 10th Amendment. Let's see, the court discusses both butter and drugs and justifying their opinion, and the opinion makes you wonder who made the judge.
All good except for that last one. Overruled. Yes, Dane.
I had also impassioned dismissal of the party's argument when he said he must be blind. I had Congress attempts to preempt exclusively state functions under the 10th Amendment. I had the court discusses both butter and drugs in justifying their opinion. The opinion discusses that if the act in dispute is considered valid, then Congress will have unlimited power, and that Congress attempts to use the taxing power to regulate the subject they fail to regulate under the Congress clause.
All sustained. I believe you are the winner, Dane. Congratulations. You have won your own new factory built and run entirely by child labor and a lifetime of free publicity through weekly CNN interviews. I believe CNN is waiting outside to interview you about your brand new factory. This game is adjourned. Thank you, gentlemen.